Hello and welcome to Manika IAS. So in the previous video we had started our discussion with the fundamental rights, right? So we are dealing with the very first article which is given under part 3 of the Indian Constitution, that is your fundamental rights, and that is article number 12. Now what does the article says? It says in this part, unless the context otherwise require, the state includes that means it is defining the term state, right? Definition. Now if you remember, while we were having discussion, we said that the fundamental rights are essentially enforceable against the state. Now when we are saying that they are enforceable against the state, that it is the state who is responsible to make sure the citizens are having their fundamental right. Now then what does that term state include? What all is coming under the term state, right? So this article is essentially defining that particular term. Okay, now what does it say? It says it includes government and the Parliament of India. That is central executive and central legislature, and then you have government and legislature of each states. That means state executive and state legislature, and then you have all local and other authorities. When you are saying local authorities, that means you are including Panchayati Raj institution, municipalities, and any other tier of the government, hierarchy in the government, and other authorities like you have some councils, SC/ST councils and all. All these are covered under this particular state definition of state, which is operating within the territory of India or under the control of government of India, right? That means even the embassies in the outside other foreign countries which are under the control of India will come under the definition of state, right? Now have you noticed that it has spoken about executive and legislature, but it didn't spoke about judiciary. Why? So do you think judiciary doesn't come under the definition of state? No. What happens is there are two functions of judiciary. One is administrative, another are judicial, where they are delivering judgments or imparting justice. Now when you talk about this particular function, then judiciary do not come under the definition of state, not under state. But if you talk about administrative function, then it comes under the definition of state. So it purely depends upon the function, that whether it is coming under the under definition of state or not, right? Now in its various judgments, Supreme Court has laid down various features of a state. So let's discuss about those. So it's in Ajay Hasija versus Khalid Mujib case, the Supreme Court says individual, it can be an individual, it can be a company, it can be a society which is acting as an agency of a government, right, is referred to as any state. So even if a private company which is imparting the role of a government, they are fulfilling the role of the government through some agreement or something, contract like that, then also that will be come under the definition of state. Okay. And further, Justice P.N. Bhagwati also laid down certain principles. It says that if any entity is having deep and extensive state control, if it is controlled by the state, that will be covered under the state definition of state. Then you have government financial resources are the primary source of funding. If there is a particular, say, school which is funded by the government, aided schools and all, then also they will come under the definition of state. If they are private schools which are not aided by the government, then they will not come. Similarly, any other entity which has the primary source of funding as the government funding, then that will come under the definition of state. Further, the functions of those entities should be public importance, and they should be having governmental functions, like we had Aadhaar, many distributors were distributing Aadhaar, right? So that was something which we call it as governmental function. Then you have government department if it is turned into a company, then also that will come under the definition of state. And this definition of state also implies a definition of state which is given under DPSP. So you remember this is very important pointer that you should remember while deciding whether an entity will come under the definition of state or not. It will help you understanding which particular fundamental rights are imposed against whom, so that it will help you, so you remember this. Now come to the next article, which is Article 13. Article 13 is dealing with the laws which are inconsistent with or are in derogation of the fundamental rights. That means which are not in sync with the fundamental rights that are given between Article 14 and 235. In this, they have given 6 fundamental rights broadly and then sub-part of it. Then this particular article is discussing the laws which are inconsistent with these laws. The very first clause says, all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision, shall be, to the extent of the inconsistency, be void. Now what does this imply? It says ki if today in 1947 we got independence, right? Even before 47, if there are any laws which are in place, right, and they are not inconsistent with the fundamental rights, they should be declared as a void. They should be declared as non-constitutional. They should not exist anymore in the country. But it also says to the extent of inconsistency. Say for example, it is a law which is having say 4 clauses, 1, 2, 3, 4, and only this particular is against the fundamental right? Then not entire law will not be unconstitutional. Only this particular provision, to the extent of inconsistency be void. Only this particular provisions will be declared as unconstitutional, and the remaining 3 will remain in place. They are not going anywhere. Only this will go. So it's not that if one provision or say 2 provision of a particular law is unconstitutional, you remove the entire law. No, only those provisions will be done away with. Okay, this is the first. Now this is dealing with the laws which were in force before the commencement of the constitution. However, it says the state shall not make any law which takes away the laws which were in force before constitution, and these were the laws which were made by the parliament. ठीक है, और ये state cannot make any laws which are taking away these fundamental rights. Okay, now in this further it is defining the term law. So if you all have gone through the very first lecture, in that particular lecture we discussed what are ordinances, what are orders, bylaws, rules, regulation, notification, customs. We have discussed this topic in detail. So if any of you have not covered that video, please go to the link. It will be given somewhere here. You can go through the link and you read the definition of these. So first it said inconsistency in the laws which were pre-existing, then the newly created laws, and now it is saying the definition of laws. So definition includes all the laws which are in force in the country, and there are different names which are being given. You can please go through and read it from the video. Then it is saying that laws in force includes laws passed or made by legislature or any other competent authority in the territory before the commencement or not previously repealed, notwithstanding that any such law or the part thereof may not be there in operation either on particular areas. Now this is just a reiteration of the same point, but what I want to bring to you is that this particular, when we are saying that to the extent of inconsistency it has to be void, then there has to be somebody who will declare it unconstitutional, and that particular body is your judiciary. And this part power of judiciary to declare any law as constitutional or unconstitutional is known as judicial review. So Article 13 specifically mention about the power of the judiciary to declare a particular law as void, and that power is known as judicial review. Let us discuss about the concept judicial review in brief. We'll take in details later, but here we are discussing in brief. See, judicial review, as we discussed, is the power of higher judiciary to declare the law unconstitutional to the extent of inconsistency. So we discussed what does the term extent of this inconsistency means, right? Now, what is the purpose of a judicial review? As we discussed, judicial review is to decide whether a law is constitutional, whether a law is unconstitutional. Right? Constitutional means it is in sync with the provisions of Constitution, and that is called as whether the law is intra-virus or whether the law is unconstitutional or ultra-virus. Right? So this was about judicial review, the definition and the purpose. So where it came from, where did the concept arrive from? So it originated in the US Constitution. However, in the US Constitution, it was implicit. Implicit means that it was not written in a clear manner. You have to read between the lines to get to the the concept itself. Say for an Indian Constitution, it is explicit, as we discussed under 13 clause 2, and further it is also implicit under Article 32 and 226. These refer to the writ jurisdiction of Supreme Court and High Court respectively. That means an individual can approach to the Supreme Court or High Court in case of violation of their rights. So in these it is implicit. Let us try and understand the term implicit and explicit in much clearer manner. Say for example, Article 19 say that you have a freedom of speech and expression. Now it is clearly written that you have a freedom of speech and expression. Okay. But if you, and that is now that is explicit because it is written, but it is also derived from that particular that an individual also have a right to stay silent. Okay. If I have a right to speak, I also have a right to not speak. Okay. Now that is implicit in that particular provision because it is not clearly written. What is clearly mentioned is your explicit. What is not clearly mentioned but it is derived from that particular point, that is implicit. Okay, so similarly in US Constitution it is implicit, however in India it is present in both explicit and implicit manner. Right? Now what is the objective of judicial review? Objective remains to uphold the supremacy of the Constitution. When we were discussing the first lecture, we discussed that India is a parliament, is a democracy in which Constitution has supremacy. Constitution is the rule and everybody is bound by the Constitution, right? So that is why to ensure the supremacy of the Constitution. Then other is legitimacy of the law, whether the law is legitimate or illegitimate, whether the law should stay in the country or it should not stay in the country. Then to maintain the federal balance so that the union or the center or state, any of them do not divert any, state to can't do. Whether the union or the center do not divert the balance of power in their favor, and then maintain constitutional balance against the same derivation. Right. Now let us discuss the principles of judicial review. There are largely three principles of judicial review. One, it says it cannot be applied suo motu. That means suo motu means by its own self. That means judiciary cannot apply the principle of judicial review on its own self. But obviously this can be done in extraordinary circumstances. It is allowed in extraordinary. But unless and until somebody is taking a particular law to the court, Supreme Court cannot apply the principle of judicial review. That is first principle. Exceptions are there, extraordinary circumstances in case of gross violation of human rights, say that is there, and Supreme Court thinks that it is appropriate for them to intervene, then Supreme Court can do, because it's something which is not usual, which is not ordinary, which is extraordinary, then it can do. Other than that, it cannot apply the principle of judicial review suo motu, right? The other is, if there are, say, two interpretation, a law is there and there are two interpretation. One is intra-virus, other is ultra-virus. That is, one is constitutional interpretation of a law, another is non-constitutional interpretation of law. So Supreme Court should always accept the constitutional provisions of law to give a decent chance to legislature also for their intelligence that they have framed that particular law, right? Because a law is not just made by one individual, it takes entire a lot of people into making of a law. So to respect their intelligence and their understanding of social and economical circumstances, the intra-virus interpretation is accepted if there are two equally appropriate interpretations are there. One is constitutional, another is non-constitutional. So always it is the intra-virus interpretation which is accepted, right? Now, it also says that it is not applicable on the laws which are not enforced in the country. Say a law was made, but it is not in force. It is not, there in the country, right? It is just on papers, not applied so far. So on those laws, judicial review cannot be applied just for the sake of saving the time of judiciary, because it will be a worthless activity if judiciary is going through all the discussions and debates. They are giving their time and the law is not even enforced. There is no point also. So these are the three bare minimum principles of judicial review. The scope and other things we'll discuss in later. This was the basics of judicial review, right? Now let us come to Article 13, Clause 4. It is very important. You need not remember the exact articles when we are discussing. I am just giving you an overview so that you understand what it is saying, right? So it is essentially dealing with the amendment of fundamental rights. What does the article say? Article says there's nothing in this article shall apply to any amendment of the Constitution made under the Article 368. While we were discussing the previous topic, we discussed that the Constitution has given the definition of law, what all is coming. According to that, it is being said that you cannot use the root of a ordinance, you cannot use the root of a rule, law, bylaws, anything to change or amend the fundamental rights, essentially, right? You cannot do that. However, Article 13 clause 4 says कि if an amendment is made under Article 368 of the Constitution that we discussed in the previous lecture, the amendment made under Article 368, if by that route any amendment is made, only through that route you can amend the Constitution, fundamental rights, right? That means you cannot use ordinary bill to amend fundamental rights. Okay, but you need to have Constitutional Amendment Act to amend the bill, right? And this article was inserted by 24th Constitutional Amendment Act, 1971. Let us first go into the history of, because this has always been a debate, let us first go to the history of this particular provision. So what happened in 1951? The state come up with the very first Constitutional Amendment Act, which amended fundamental right under Article 15, which added special provisions for socially and educationally backward SC and ST. Then it also added 19th clause 2, which added restriction to freedom of speech and expression. And then Article 31A was added, which was dealing with acquisition of land by state. Okay? Acquisition of land by state. Okay. Now, when these three provisions were added to the Constitution, so it was taken to the Supreme Court saying that fundamental rights cannot be amended, right? Because it is again taking away some fundamental rights, it is altering the fundamental rights. It was taken under Shankari Prasad versus Union of India 1951 to the Supreme Court. However, Supreme Court held the validity of this particular constitutional amendment. It says that Parliament under Constitution has two different type of powers. One is your power that Constitutional Assembly had, legislative power. Second is your ordinary power of making changes to the Constitution. Now it says these are the two different powers that Constitution has, and this essentially is coming from Article 368, right? So it upheld, and it says that fundamental rights can be amended, but it can be only amended using Article 368. Other than that, it cannot be amended. Further, all these three are valid because the Parliament essentially has two powers. One is legislative power and other is power of Constituent Assembly, right? So this was given to them by the constitution makers, and this notion went on through many cases. During Sajjan Singh case also it goes on, and however it was in Golaknath versus State of Punjab, which was a 11-judge bench. See, constitutional benches are the benches which have more than 5 judges, and by a norm, a bench of a larger judge can always undo the decision of a smaller bench. Bench of less number of judges cannot undo the decision of larger bench, right? So if this was 5 bench during going through another case, Sanjay Singh, so in the Golaknath case there was 11-judge bench, which again took up the same topic, because in the 17th Constitutional Amendment Act it restricted fundamental rights further. However, in this Golaknath case, the court overruled this decision. It says that the government do not have any right to amend the fundamental rights under Article 368, because if you will read the Constitution, you will realize that Article 368 was written as the procedure to amend the Constitution. It didn't say that the power to amend the Constitution, right? So that the wording was, the heading of Article 368 was procedure to amend. Procedure to amend. So it says that the notion of this particular this Shankari Prasad case, which says that it also have power of Constituent Assembly to make laws. It says the Parliament do not have this power and only have power of ordinary legislative. Okay? Because the Article 368 read procedure to amend the Constitution. Now after this, again in 24th Amendment, Constitutional Amendment Act was brought in by the Parliament in 1971, and in this particular amendment, they changed the title of Article 368 from procedure of amendment to power of Parliament. To amend the Constitution. They changed the title, okay, and they included this particular clause and also a clause in 368 which allow them to amend the fundamental rights. Okay. Now coming to this is a very important landmark judgment of 13 judges bench, Keshvananda Bharti versus State of Kerala 1973. Now this again overruled the judgment made by Golaknath, and it upheld the 24th Constitutional Amendment which was made by the Parliament, and it says that okay, fine, Parliament do have a power to amend the Constitution as well as amend the fundamental rights, but it is subject to the basic structure of the Constitution. What does that mean? They introduced the doctrine of basic structure. That means you can alter the constitution, you can alter the fundamental rights, but you cannot change the basic structure, basic premise, basic principles of the constitution. Right, now let us discuss about the basic structure. It says, so basic structure is basically, what does it mean? There are few principles that cannot be changed no matter what. No matter what happen, you cannot change. Like Indian constitution, Indian country, West secular country, you cannot take away the provisions which are making it a secular country. You cannot alter the federal balance. You cannot alter secularism. So it says that, and many provisions were later added to it. It was like rule of law, then parliamentary system, free and fair election, balance between fundamental rights and DPS fees. Again, judicial review was also added in Minerva Mills case, right, under the provisions of basic structure. So there is no one definition of a basic structure in the sense ki what all comprise of basic structure, but in various decisions of the Supreme Court, they have added one or multiple features of the constitution, including secularism, balance of power, separation of power, federalism. They are the principles, they are the basic premise of the constitution. You cannot change the nature of the constitution. You can change the provision, but not the primary nature of the constitution. Then again, in 42nd Amendment Act 1976, Parliament again came up with and added Article 368(4)(5), which take away the power of judicial review and says that there is no bar on the amendment power of the Parliament, and the amendment are not also subject to judicial review. Okay? So they take away judicial review and gave them complete authority to amend the constitution. Then in Minerva Mills case, in 1980, Supreme Court held that this particular amendment is void, this is nullified, and judicial review, balance of power, and are the basic structure. And similarly, the doctrine of basic structure keep on developing from one case to another, and we have certain features which are the essentials of the basic structure. So these are the very important topics that we have discussed. One is your judicial review, definition of state, then we have discussed constitutional amendment of fundamental rights, and then the origin of the doctrine of basic structure. So read about this, and in the next article, in the next particular lecture, we'll discuss Article 14, that is your right to equality. We'll start with right to equality.